Who has more rights, a trustee or a beneficiary? When comparing a trustee and a beneficiary of a trust, it's difficult to say who has more rights because they each have completely different roles, powers, and responsibilities. While the trustee has a great deal of authority to administer the trust and manage its affairs, they also are bound by a fiduciary duty to act in the best interest of the trust beneficiaries. And although a beneficiary generally has very little control over the trust management, they are entitled to receive what the trust allocates to them. And they're also entitled to know what's going on. In general, a trustee has extensive powers when it comes to overseeing a trust. The specific rights of any trustee are, in part, going to be dictated by the terms of the trust instrument. However, here are some of the rights that most trustees generally are going to have. 1, the power to collect, hold, and retain trust property. 2, the power to accept additions to the trust. 3, the power to invest and deposit trust funds. 4, the power to manage, control, divide, develop, improve, exchange, partition, change the character of, or abandon trust property or any interest in trust property. 5, the power to encumber, mortgage, or pledge trust property. 6, the power to insure the trust property against damage or loss and to insure the trustee against liability. 7, the power to borrow money for any trust purpose, to be repaid from trust property, obviously. 8, the power to manage claims by and against the trust. 9, the power to pay taxes, assessments, reasonable compensation of the trustee as well, and employees and agents of the trust, and other expenses incurred in administering the trust. 10, the power to make loans out of the trust property to the beneficiary. 11, the power to pay any sum of principal or income distributable under the trust to a beneficiary. 12, the power to hire people, including accountants, lawyers, auditors, investment advisors, etc. 13, the power to execute and deliver all instruments needed to accomplish or facilitate the other powers we just went through. On the other hand, the rights of beneficiaries are more limited, but they do include 1, the right to receive a copy of the trust document, 2, the right to receive timely distributions according to the terms of the trust, 3, the right to receive and challenge accountings of what happened with the trust, 4, the right to be kept reasonably informed about the trust administration, what's going on with the trust, 5, the right to impartial treatment by the trustee. The trustee can't pick favorites. And 6, the right to petition the court to have a trustee suspended or removed or to force them to account. Can a trustee override a beneficiary? Yes, a trustee can override a beneficiary if the beneficiary requests something that's not permitted under the law or by the terms of the trust. Under the California Probate Code, here section 16,000, trustees must administer the trust according to the terms of the trust instrument. This means that if a beneficiary disagrees with the distribution schedule or any other terms that are outlined in the trust, the trustee must disregard the beneficiary's wishes and carry out the trust's written requirements. If the terms of the trust are ambiguous, a trustee should consult with legal counsel before taking any action. If the ambiguity cannot be resolved with the consent and agreement of the beneficiaries, then the trustee can ask the probate court for guidance through filing a petition for instructions with the probate court. Can a beneficiary override a trustee? Generally, no. Beneficiaries can override a trustee unless the trustee fails to follow the terms of the trust or if they breach their fiduciary duty. Even when a beneficiary disagrees with the trustee's actions, they typically can't override the trustee just because they don't like what the trustee decided. Unless the trustee clearly violates the terms of the trust or the law or breaches their fiduciary duty, there's going to be little a beneficiary can do. However, suppose a beneficiary thinks that the trustee is abusing their power or failing to follow the requirements of the trust. In such a case, they have the legal right to ask the court to suspend or remove the trustee from their position or to order the trustee not to do what they shouldn't be doing. How can a trustee or beneficiary protect themselves? Whether you're a trustee or a beneficiary, the best way to protect yourself is to seek assistance from an experienced trust attorney. As a trustee, a lawyer can help you understand your duties and ensure you're complying with the terms of the trust instrument and your legal obligations. We suggest that new trustees retain a trust attorney when they first consent to serve as trustee, before any troubles arise. That way, your lawyer can ensure that you fully understand the requirements of your position as trustee so you can avoid making costly mistakes that could expose you. For beneficiaries in a dispute with a trustee, a probate litigation attorney can review the trustee's actions and advise you on the likelihood of a trustee being removed or suspended, or even successfully sued for their misconduct. Even if the trustee hasn't committed a breach of trust, they may nonetheless be the subject of removal for other causes. So discussing your situation with a knowledgeable trust litigation lawyer is going to be the first step you should take if you're having issues. Have questions? At RMO, we protect people like you every day. Schedule a free consultation at rmolawyers.com or just give us a call or shoot us an email. Thanks for watching.